I'm going to differ from my colleagues in a couple of ways. First, unlike my colleagues, I'm going to sit because, unlike Chris at 5 o'clock in the afternoon, I'd much rather sit. Secondly, I'm going to differ from my colleagues in the nature and emphasis of the study that I conducted. My study did have an empirical component, but I had an extremely small sample, so while the results were probative and illuminating, it's not the dominating force of the piece. It's predominantly a much more legal and normative and structural kind of piece. What I dealt with in this study was the doctrine of si pre. That's two words, CY and then PRES. And what it basically means is that in a class action where you have a whole bunch of absent plaintiffs who simply can't be found or who won't take overcome the inertia to file a claim, instead of letting that money revert back to the defendant, it is designated by the court or by the parties to go to a charity that it has some relationship to the case. So it's basically the designation of unclaimed funds in a class action to a specific charity. Now, the first problem we have to discuss is how we actually are to pronounce the name of this doctrine. You can cause arguments at a bar. The three things you shouldn't discuss are politics, religion, and how you pronounce this doctrine. The technical pronunciation is si pre. It comes from a longer French phrase developed in the Middle Ages, and under that version it is pronounced si pre. I have heard, however, other lawyers refer to it as si pre, and I cannot dispute the fact that the award that Major League Baseball gives to the best pitcher is not the Cy Young Award. So if you want to refer to it as si pre, it's a free country.
But not in his class.
No, and if you mispronounce it on the final, you get marked off. The problem with this doctrine is that it effectively transforms the underlying DNA of the law that is being enforced. And it is simply too big a dog for the tail of a federal rule of civil procedure to be able to wag. Now, the origins, and you will hear plaintiffs' class actions lawyers say the origins of this doctrine go back 1,000 years. And there is some level of truth in that statement, but only a little. The doctrine began in the law of trusts, and you can trace it back to Justinian, though it had its dominant use in the Middle Ages. If an individual set up a charitable trust in his will, and it turned out for legal or practical reasons it was impossible to fulfill the goal of that trust, there developed the doctrine of the second best. The court would find the second best way to dispose of those trust funds. The classic example is the will of George Bernard Shaw. George Bernard Shaw was obsessed with the phonetic spelling of the English language. The fact that GH could be equivalent to an F bothered him enormously. So in his will, he set up a trust to go to the study of the conversion of the English language to phonetic spelling. Unfortunately for him, there was no such organization. So what the court did in the exercise of si pre was simply give it to the Library Association, figuring that was close enough for government work. And in its original context of trusts, it seems to make perfect sense. It is quite a jump, however, from the law of trusts to the adversary system of litigation where substantive law is enforced. When you enforce substantive law, there really is no second best. Either you provide the relief authorized by the law or you don't provide relief. So I was wondering, when did it get transformed from this trust context, where its origins were quite venerable, into this adversary process context? And I had research assistants trace what I refer to as the source of the Nile. Find me the point at which it was transformed. And what they came up with was a student comment in 1972 in the University of Chicago Law Review, which first suggested drawing this rather dubious analogy. Actually, I've tracked down the individual who wrote this note because he's an attorney at Sidley Austin, where I'm connected. And I asked him about this, and he said that if he had known what it was going to lead to, he never would have written it. But that was the first attempt to transform the trust doctrine to the litigation doctrine. And it was in the mid-1970s that federal courts began to use this doctrine as a means, basically, of punishing defendants, not letting defendants get away with what the court had found to be illegal behavior simply because they couldn't find a plaintiff to compensate. What our study did on the empirical front was look for every case we could find in federal court. It was confined to federal court, where this doctrine was used. And it's a relatively small number. It's in the 30s. But its use has increased dramatically, almost double since the year 2000. From 1970 to 2000, it had a limited use, and then it has doubled since then. And it's used both in settlements and in coerced awards under the class action litigation process. The problem can be viewed in several different ways. First, it is inherently undemocratic because under the disguise of a procedural rule, as if the court is saying, nobody here but us chickens, we're just enforcing the procedural rule, it is transforming the underlying DNA of the law. The law has two components to it. It has a proscriptive component. It says, you cannot do X, Y, and Z, and then it has a remedial component. There is a remedy for that particular proscription, and the two are tied together as a statement of the substantive law. And what are the available remedies? There's criminal enforcement, there's administrative enforcement, there are civil fines, and there are compensatory remedies. And the laws we're talking about have decided to kill two birds with one stone. They impact social behavior by making victims whole. So they punish a defendant and simultaneously compensate a plaintiff. And plaintiffs' lawyers in class actions are very controversial. They have been the key figures in presidential disputes and presidential elections. But people generally decide to accept plaintiffs' lawyers because they get compensation for victims. They help make them whole. CPRE doesn't do that. CPRE basically imposes a civil fine. It says, give money to the Red Cross, give money to the Salvation Army. The Red Cross has not been injured. The Salvation Army has not been injured. We have taken the bilateral adjudicatory process where victim sues perpetrator to make the victim whole for the illegal damage they have inflicted, and introduced a trilateral element. We have introduced a third party into that mix, somebody who has no standing, who has not been injured, and there is an order of compensation. So simultaneously, look what that does. One, it undemocratically, through the guise of procedure, transforms the underlying substantive law from a compensatory remedy, which is what the law provides, into the equivalent of a civil fine. And secondly, it does so by undermining the case or controversy requirement of Article 3 of the Constitution. Article 3 requires that there be an injury in fact, there be traceability, and there be redressability. The injury in fact must be traced to the defendant's behavior, and that injury must be redressable by the court. When you use that tripartite model for the case or controversy requirement in the context of CPRE, we can see it's a complete disconnect. You have a party who hasn't been injured, who has no harm that is traceable to the defendant obtaining the redress. So you have a simultaneous problem of a political alteration of the substantive law and a basic violation of the structure of federal adjudication. Now, many of you are, I'm sure, are state judges. States are not controlled by Article III. They don't necessarily have a case or controversy requirement, though many of them do. But the basic deceptive nature of what CPRE does is relevant regardless of whether you have an Article III case or controversy requirement, because the underlying law is being transformed. Now, basically what's happening is we are providing a cover for what I refer to as faux class actions. I remember I used to go to Washington in the 1980s, and there on the street corners there'd be cardboard cutouts of a smiling Ronald Reagan and a photographer, and you could put your arm around that cardboard cutout and they'd take a picture and it would look like you were actually standing next to Ronald Reagan. But you weren't. You were standing next to a cardboard cutout. And that's what many of these class actions are. Are there injured victims? Let's assume there are. But they didn't decide to bring the suit. Many of them aren't even aware that the suit's being brought. The claims are for such a small amount that they're not going to possibly file the claims. But the plaintiff's lawyers, who are the real parties in interest here, bring these class actions with that cardboard cutout of a class, and when push comes to shove and they can't find those people to be compensated, they end up giving the money to charity so that they can get 1/3 of it. This is basically a fundamental distortion of the system, and what my study has tried to show is that the CPRE system undermines the adjudicatory system and furthers all these litigation pathologies of the class action. So does it mean that perhaps we wouldn't certify a lot of these classes? I think it would inevitably mean that. Does that mean that defendants who violate people's rights necessarily should get away with it? That's an issue for the democratic process. The class action procedure is an aggregation device of pre-existing substantive claims and simply can't be used to alter the nature of those claims. Thank you.